Welcome to Learn Short and Typing with VIKAS Sir. Skill test for trial passage Punjab and Haryana High Court. Exercise number 11 and 12. 840 words, 80 word per minute. Be ready, start. To find out whether there was any reasonable excuse for the applicant to live separate from the applicant, the allegations of the non-applicant are that the applicant's family members gave beating to the non-applicant and dowry was demanded by the family members of the applicant and the applicant himself. In support of said pleading is vague and the non-applicant gave absolutely vague statement that the applicant was harassing her and used to beat her also. She was not given meals. She was closed in a room. She called her father and her father took her to Jaipur. There is no specific incident disclosed by the applicant either in the only to the divorce petition or in her statement. Not only this, but she did not disclose during period of 2 years when she was given beating and when she was closed in the room. It is admitted case as she admitted in the statement that she never complained against her in-laws before her parents or her family members. It will be worthwhile to mention here that in earlier proceedings under Section 9 of the Hindu Marriage Act, she clearly stated she is not willing to live with the applicant on any condition, but when her statement was recorded in the present proceedings on 5/11/1999, she stated that in case she is not given beating and there is no demand of dowry, the non-applicant is ready to live with the husband. In view of her earlier statement recorded on 16/4/1994 in the proceedings under Section 9 of the Hindu Marriage Act 1995, it is clear that her subsequent statement is afterthought only. It is not a case of the non-applicant that situation improved thereafter. Therefore, she was shown her willingness to live with her husband. Even non-applicant's father also gave vague statement about the demands of dowry and man torture to the non-applicant. The non-applicant and her father to improve their case in proceedings under Section 13 of the Hindu Marriage Act, but both are not trustworthy witness in view of their statements on oath given earlier as well as from their cross-examination. The non-applicant heavily relied upon the latter exercise A1. In the latter exercise 1 dated 24/12/1994, the applicant's father wrote to the non-applicant's father that they gave wrong thing to the applicant. It appears that applicant's father referred non-applicant as wrong thing. Their provisions do not later on the powers of the applicant court to grant instant decree of divorce. The appellate court is competent to grant instant decree of divorce without reference to the time limit prescribed under this subsection. In that case, marriage took place between the parties on February 19, 1978. Since January 1980, they were living apart. Para. However, a petition filed for divorce by consent under Section 13B of the Hindu Marriage Act is required to be kept in abeyance for a minimum period of 6 months. This is in sharp contrast with a petition for divorce by consent under Special Marriage Act, which is liable to be kept in abeyance at least for 1 year. This liberalizing trend of law in the matter of granting divorce by consent cannot be lost sight of by courts in interpreting that section. But even the clause (2) of Section 13B requires a court not to pass a decree for divorce before 6 months on time lapses and after 18 months of time passes from the date of filing of such a petition for divorce by mutual consent. This is the last hope of the legislature for saving the marriage. The intention of the legislature is to provide a minimum period of 6 months for 13B(2) of the Hindu Marriage Act is applied to the present application made by the parties in this case on 12th July 1985. We have to adjourn this case till January 1986 for passing a decree for divorce under that section, notwithstanding the fact that we are of the opinion that there is no chance of reconciliation between the parties who have been living away from each other for the last 4 years and are today most anxious and ready to obtain such a decree here and now. That situation raises somewhat an important legal question as to the meaning which we should attribute to Section 13B(2) of the Hindu Marriage Act. That question is whether the legislature intended to Section 13(b) of the Hindu Marriage Act should be treated as mandatory provisions of law, or the legislature intended that section to be treated merely as a directory provisions of law. We have already noticed the language of Section 13B. On first impression, it is not impossible to hold Section 13B to be mandatory. Full stops. स्टूडेंट ये आपके 800 वर्ड्स है, इसको टाइप कीजिए। टाइप करने के बाद इसको आप मैच कीजिए। पीडीएफ आपको टेलीग्राम चैनल पे मिल जाएगी। टेलीग्राम का चैनल आपको डिस्क्रिप्शन बॉक्स में मिल जाएगा। और जिन बच्चों का आज की सीपीटी है, आज की और कल की जो सीपीटी है, उसके लिए ऑल द बेस्ट सभी बच्चों को। जो भी आपने सीखा है उसको अच्छे से इम्प्लीमेंट करना। स्टेटमेंट को, खासकर जो स्टेटमेंट है, स्टेटमेंट को अच्छे से रीड करना। रीड करने के बाद तुरंत ही अगर आपने अच्छे से प्रैक्टिस की होगी तो आपका अच्छा ही आउटकम आएगा। थैंक यू वेरी मच। हैव ए गुड डे।